And we are now live, Senators.
All right, thank you. We're back. This is Senate Health and Welfare, continuing our discussion on our bills S91 and S89. And we have with us Dr. Ravin, Simi Ravin. Welcome. Why don't you introduce yourself for the record, and then we welcome your testimony.
Thank you so much. Thank you. Thank you for having me and allowing me to share some of my thoughts on the legislation you're considering. My name is Dr. Simcha Ravin. I'm going to share some slides with you and also give a more in-depth introduction of my background.
Okay. Are you sharing screen? Can you do
I would
that?
like to share screen if I may.
You should be able to now, Doctor.
Thank you. Thank you. I hope you are all seeing my screen now. As I said, my name is Dr. Simcha Ravin. I'm the immediate past president of the Vermont Medical Society, and I serve on faculty at the University of Vermont and Yale University School of Medicine in the Division of Law and Psychiatry. I'm the Chief Medical Officer at Howard Center, Vermont's largest designated agency. I'm also trained in forensic psychiatry, and I'll give some background on what that field is and what that training means. I'm a physician and completed training and board certification in adult psychiatry and additional training in forensic psychiatry. I've served on faculty at Yale in the Division of Law and Psychiatry for 9 years, where I teach forensic psychiatry fellows. Forensic psychiatry is a subspecialty that focuses broadly on the intersection of psychiatry, of mental health and law, and this encompasses a number of different things. Among them, the care of individuals who experience mental illness and criminal justice involvement. This field also encompasses violence risk assessment and broadly psychiatric and mental health evaluations for the courts. Relevant to this proposed legislation, I perform competence to stand trial and criminal responsibility or insanity evaluations. I both supervise trainees, and I have a forensic private practice in which I perform these evaluations. The topic of this proposed legislation is really so very important and timely in Vermont. I'm deeply grateful to the work of this committee in addressing this really vital issue.
Doctor, oh, here you go. All right. I was going to say your slides hadn't moved, but so now they are. We're good.
Yes, thank you. I'm going to talk about 3 things today. There are many things I could comment on, but I wanted to focus on 3 different areas. The separation of competence and criminal responsibility or sanity evaluations. I'm going to use the terms criminal responsibility and sanity evaluations interchangeably. I prefer the phrase criminal responsibility, given that it's somewhat less stigmatized than sanity. Though I want to make sure that I'm broadly understood because both are used. Second, I'll comment on support for release of relevant records to the examiner. And last, I'm going to talk about why development of a competence restoration program is important and would be helpful for Vermont. So, why separate competence and criminal responsibility or sanity evaluations? In short, this practice of only evaluating criminal responsibility in a competent defendant adheres to professional standards. Professional standards for forensic psychiatrists dictate that it is really only ethical to evaluate a competent defendant. I also think that this will increase access and decrease wait for evaluations because many forensic psychiatrists will not perform combined competence and sanity evaluations, i.e. performing a competence evaluation on an individual having an assessment that they're not competent to stand trial, then going forward with a sanity evaluation. Most forensic psychiatrists and our professional standards dictate that we stop the evaluation and hold when we will give the recommendation that someone is not competent to stand trial. So I think this would actually increase access issues. Certainly that is my practice and the recommendations in the field. So why do we have these recommendations? Why do we not evaluate incompetent defendants for sanity or criminal responsibility? There are a few reasons here, and I'm going to highlight three. And a defendant who's been found not competent to stand trial or been evaluated, and that is the recommendation, often has impaired reasoning, illogical reasoning or irrational or self-defeating reasoning, and would not be able to rationally choose a defense strategy because of that impairment. They may also likely be unable to bring forward important exculpatory evidence that or recount a clear and logical narrative of their state of mind at the time of the crime. So it is essentially an issue of fairness and dignity. And as I mentioned, it's in adherence with the professional standards for forensic psychiatrists and the recommendation of the American Academy of Psychiatry and Law that an evaluation for criminal responsibility be suspended if someone is not competent to stand trial. I was really pleased to see that that the draft of S91 I reviewed has a provision for release of all relevant records to the examiner. I strongly support this. In my experience, limited access to records hinders examinations, makes less accurate examinations, and also limits the usefulness of reports and recommendations. We often include recommendations for treatment and hypothesize why someone is not competent or has diminished criminal responsibility. And without records, often it is very difficult to understand these issues and make reasonable inferences. The last thing I'm going to comment on is competence restoration. This slide shows a recent volume that has a model program outlined for competence restoration programs. And I'm going to highlight some of those elements of a model program, and then I'll talk about what does the literature say about does competence restoration work and in what settings. So some of the core elements of a competence restoration program, an effective competence restoration program, are systematic assessment of competence and an understanding of the specific reasons why an individual may lack competence. Another core element is an individualized treatment program that addresses those underlying reasons and deficits for lack of competence. Education is a core piece of competence restoration, primarily education on the courtroom, understanding charges, sentencing, plea bargaining, roles of courtroom personnel, and so forth. This slide talks about other important elements for a model competence restoration program. Anxiety reduction may be really important for a defendant, and teaching anxiety reduction techniques so that a defendant can successfully navigate the courtroom proceedings. Additional education and supports for individuals with intellectual or learning disabilities. Periodic reassessment to see if someone has gained or regained competence, and also if someone has not, where the focus needs to be in restoration. Medication can be important if there's an underlying mental illness or other medical illness that is affecting competence. Yes, Senator Lyons.
No, I'm fine.
Oh, I'm sorry. I thought you asked me a question.
No, I don't know. You
Okay.
may have heard the hallway noise.
Thank you. It's hard to tell. Risk assessment can also be extremely important to understand where competence restoration should take place in the community or other settings. And I'll comment on that a bit. Oh, I animated this one a bit. So this slide highlights a recent article looking at does competence restoration work? How effective is it? What is the impact of setting and other characteristics of defendants who are participating in competence restoration programs? This article reviewed recent literature and synthesized it to try to answer that important question. And as you can see, cost is highlighted here, cost per day, and it's really very broad. The rates of restoration, what percentage of the incompetent defendants were restored to competence? Some of the characteristics of the people served in those programs, and the type of crime or risk level of the crime for which they had criminal charges. One of the things I want to highlight here that I thought was kind of curious is that if you look at the last column where it says outpatient restoration, fewer are, a lower percentage of defendants are restored. And I thought that was sort of curious. And the authors posited, and I agree that there are a couple potential reasons for that. First, individuals who are in outpatient restoration programs may have less serious criminal charges, pose less violence risk in the community, and be appropriately diverted to treatment programs. They may also in the community have challenges that in a secured environment people don't face. The literature reflects that people who are found not competent to stand trial often experience lower socioeconomic status and are more likely to have difficulty with transportation and housing insecurity. And that can be something important to consider when establishing an outpatient restoration program or understanding some of the challenges.
Can I ask you a question here?
Certainly.
So this article is written based on a specific type of program, or in I don't know which states we're looking at or state, and we're moving, or we've tried to move into the community-based system where treatment will be much more outpatient driven, and we've got perhaps more capacity given, even though it's not enough. But so can you speak just to where the data comes from, which state, and how it fits with who we are in Vermont?
I gladly. The authors of this article went to several different databases and looked for all of the relevant literature that looked at competence restoration programs going back, and they actually went back quite a ways, for several decades. So it stretches across different settings in different states. It would be useful to, and I don't actually know offhand the details of the individual studies. They considered a large number of studies and then synthesized the data. The senior author is a close colleague of mine at Yale, and if it were useful for us, I think would gladly discuss the raw data with us.
Well, I mean, this is really interesting and I think informative, but just trying to understand where we are, how we fit into this pattern of a lower percentage of restoration.
Yeah. Because
we are moving more and more and more toward outpatient treatment. That's all.
Yes, absolutely. You know, we don't have a formal restoration program in any setting, correctional, hospital, or outpatient settings. And the authors comment, and I agree really strongly that it's really important to have competence restoration focused on people who are charged with very serious crimes, and that diversion is important for people who can appropriately be diverted, and that the largest number of people possible should be restored and participate in restoration programs in the least restrictive setting, i.e. in the community.
Thank you.
I think that fits our goals and resources. And there's been an increasing movement of having fewer resources focused on restoring people who have misdemeanor and other less serious crimes, and a focus on more restoration for more serious crimes. And I think that's appropriate for our setting and really needed. And I'll talk a little bit about why I think that's so important and vital for us.
I'm going to ask if you could move right along, simply because our time is very precious this morning, and not
Certainly.
that your testimony isn't equally precious, but as quickly as we can, or efficiently as we can get through, would be great.
Certainly. I was going to highlight two cases that illustrate why competence restoration is important. I'll just talk about the first one, if I may, and then end there.
Sure. Okay.
So I'm going to highlight in brief a case of an individual. I've changed some details so it's not identifiable. I'm going to call this individual JP, a 35-year-old man who had criminal charges related to child pornography possession approximately 5 years ago. At that time, he was evaluated and found not competent to stand trial, and ultimately his charges related to child pornography possession were dropped. He had some general mental health treatment and in an inpatient setting and returned to the community. And more recently, he experienced an episode of psychosis and also admitted to possession of child pornography again, and also a belief that he had a mutual romantic connection with a young girl. In my interactions with this individual, I think that he likely could have been restored to competence and resolved these charges. And we have, significant challenges because we don't have a process in place to do that. He, with the second episode, was discharged to the community, and an order of non-hospitalization was put in place, but he did not follow the conditions of the order of non-hospitalization. Some of those were adherence to treatment for sexually problematic behaviors, abstinence from substances, and so forth. But he also didn't meet threshold for revocation of the order of non-hospitalization. So we're faced here with a conflict between an individual's wishes to not engage in certain kinds of treatment and abstinence from substances and important community safety interests. So I'll pause there and I will stop sharing my screen, and I'm happy to address any questions.
Thank you. So what I'm hearing from you is that it's important for us to consider a competency restoration program in our state. Do you feel that what we have, or what do we have? I mean, where are we in the scheme of things?
So to state it broadly, we do not have a competence restoration program. We have a competence evaluation system where individuals are evaluated for competence to stand trial. And then we have a very idiosyncratic process about what happens after that. And in my experience in multiple different settings, both at a designated agency treating people who are on orders of non-hospitalization, and in my experience in leadership in inpatient settings, what happens more often than not is that someone's criminal charges are dropped, and that poses a very difficult bind around community safety. And as I practice as a psychiatrist, and I treat individuals who have criminal justice involvement and have exhibited significant violence and aggression. It's a very difficult status quo that is not necessarily good for the individual or for the safety of the community that they reside in.
Okay, thank you. I have one last question. I think it's one last question. Others may well. You are a forensic psychiatrist, and one of the proposals in the bill is to include a forensic psychologist, PhD level, for competency evaluation. And so could you give a brief comment on your perspective? And what we have heard from our Defender General is that we're outliers in our state. We don't have the provision that other states have. I guess, was it Rhode Island and Connecticut?
Only us in Rhode Island.
Only us in Rhode Island. Oh, there's two in the country. Okay. So can you speak to that? Because there is that section in the bill that allows for the forensic psychologist to perform a competency evaluation, and then there's a sunset next year with some reporting back on how things go.
Thank you. I've thought about and considered this issue a bit, and I think that in general, forensic psychologists, they have a very rigorous training process to and familiarization with forensic issues. I think the one sort of deficit and potential blind spot that I think would need to be considered and addressed is some people, some individuals are found not competent to stand trial because they have a medical illness or medical condition that impairs their competence. And with the addition of forensic psychologists who have rigorous training that does not include medical training, the individual assigning the evaluations would need to be mindful that when there's a concern that there's a underlying medical illness, that should be assigned to someone with medical background, i.e. the forensic psychiatrist.
So a question for you then, are those medical records available to folks? Is that transparent?
I'm sorry, what was that again?
Are the medical records available so that one can make that determination prior to the competency evaluation?
I think that that's a good question. I think that it's promising to have forensic psychologists do competence and sanity evaluations. I think it would be important to study that issue if the medical records would elucidate to whom it should be assigned. I think further study would be useful and important to see, how this has worked for other states and how they grapple with that issue. In my experience, both supervising forensic fellows and doing evaluations myself, it's not uncommon to find someone who has a medical condition that contributed to their lack of competence. For instance, an endocrine disorder or corticosteroid influencing their mental status. It's not unusual, but I'd be interested in how other states address this issue and appropriately assign evaluations.
Okay, that's very helpful. And the question about having access to medical records, I think, would be important so that any referral for evaluation could be done in a way that might be useful for psychiatrists as well as psychologists.
Yes, absolutely.
All right. How other states do it, that's a big question. Good. Okay, other questions, committee, for Dr. Ravin? Good. Okay, good. Thank you so much. Really appreciate your time. And I know it was just kind of a quick turnaround for you, so we appreciate you taking the time out of a busy day.
Thank you so much, and thank you so much for hearing me. Thank you.
Thank you. Jill, did you want to make a couple comments, and then we're going to bring Eric up?
Yeah.
And also, I'm gonna, the Defender General is here. If you don't mind, I'm gonna ask you to just make your comment about other states that, or what you know briefly, when we get there.
I was hoping at some point I could.
Yes, let's do that.
Okay, Jill Sudhoff-Garrett, and I'm representing the Vermont Psychiatric Association and the Vermont Medical Society. And thank you for listening to Simi. She's amazing. And thank you for taking up this bill. We feel like it's extremely important. And we feel like separating the competency and the sanity evaluations will really help with that access issue. Because like you heard, it's really best practice. And so that will really open up the pool of forensic psychiatrists that will be willing to do these evaluations. We do just want to say that we think you should study it first before you open it up. Once you provide the separation of the competency and sanity evaluations, you're going to help bring more access in July. And so you're already doing a study on other doctoral level mental health providers in this amended version. And so we're saying, why don't you just add the doctoral level psychologist to the study instead of studying it first? Like Simi said, there's actually just some medical issues that could be overlooked. And so we feel like it's very important to have that medical background. Simi brought up some of the issues, but even something like Chantix can have delirium associated with it. And so that is really gonna provide that temporary incompetency. And so you really wanna have somebody who's looking at that with a medical background. And then, you know, we really feel like the competency restoration opportunities in this bill is super important. And then there was one other issue, and I don't really understand. One of our members said that they were concerned about the part of the bill that has the defendant paying for the competency evaluations. And I honestly think that is for the second, you would know better, but is that for the second competency evaluation if
Yeah, why don't we'll have the Defender General come up and testify briefly.
Yeah, we just wouldn't want that to reduce anybody's ability or inclination to have the evaluation. So.
Thank you. Okay, and a question I have for you is, I failed to ask Dr. Rabbit for her slides. If we can get those slides, I know you were in communication with her.
Yes.
That would be helpful.
Yeah.
And then, and your testimony didn't come up. Some of it did, some of it didn't. So make sure that Alex has all your testimony. That'd be helpful.
Yeah. And in my testimony, there's just some data on the most recent healthcare census report on doctoral level of psychologists.
Okay.
It's also very few. So again, we feel like just studying this first would be great. And we understand, you know, the concern of the,
there is a backlog, and we will look at it. We will look at it. Thank
Okay.
you.
Thank you.
Appreciate your time.
Yes.
I should say questions. Any questions for Joe? Yeah. We're good? Okay. No, we're good. Did you have a question?
I got a general question.
Oh, okay.
I'm trying to think of the organization, you know, how many psychiatrists we have, how many psychologists do we have, and could the psychologists work for the psychiatrists?
Well, this is a discussion
Okay.
that, yeah, when we'll try and get there, because I'm thinking there's something that we need to add into the bill, to amend the bill. And so I think I've heard that there are 17 forensic PhD psychologists. I don't know how many psychiatrists. Forensic, I think, are very few in the state.
Right.
I don't.
Yeah, I do have the data in here and it looks like it's around, for full-time, it's around 7 doctoral level psychologists. So one of the things that, I think Cindy alluded to is just having that oversight, being there to help and, provide that, guidance as well. So we'll double check if
Do we have that in your testimony that I can't open? That's
you can't open it.
well, no, it's not you, it's some technical glitch. Anyway, we'll fix it.
I can
Williams
send
has
it
it.
Yeah, I've got it.
separately
You've got it, it's
Did you
my
refresh?
iPad, it's been very unreachable, so,
Oh, okay. Well, let me know if you need anything else as well.
thank
Thank
you. Yeah, thank you, this is great. Yes, Public Defender Valeria, would you like to take a seat? Defender General, I'm sorry. I should get my title right. And just as I said before, Ruth, Senator Hardy, you were out. What we're trying to do is to get some testimony where we can provide input on both of these bills. And we'll get testimony today. We'll try to put together, I made some recommendations earlier about areas, and we're getting interesting information that we can add value to the two bills. And then I'm working with Senator Sears to make sure that we'll have an opportunity to put those amendments in place before the second reading or during second reading. So we're at the end game here. We'll do the best we can. These are the kinds of bills that we really should have in committee, and we will work to make that happen going forward. Welcome.
Thank you for having me. I'm Matt Valerio. I'm Defender General. I appreciate the testimony of Dr. Revin, but as is typically the case, there is some significant conflict between the American Bar Association best practices as recommended for the evaluation of individuals with mental illness and what the doctors, some doctors at least, suggest is the best way to handle the division of and evaluation of competency as opposed to sanity. And I didn't know how much you wanted me to get into. I've been an attorney for over 35 years. I've handled hundreds of mental health type cases, and I've handled some of the most serious of these types of cases, homicides, sex cases, and the kidnappings, all kinds of things like that. And
We don't envy your work at all, which is amazing what you're doing.
well, this particular area is one that I have I've published some stuff in this area and have provided dozens of trainings on how attorneys should handle this particular type of thing. And unfortunately, very severe mental health issues that for the least severe crimes and all the way up to the most severe crimes, and some of the most profoundly mentally ill and some of the most profoundly dangerous people are actually on the very low end of the criminal spectrum when they get their charges. And that is a difficult thing to navigate, but there are clear directions for what attorneys need to do. Now, I went through in detail the bill with the Judiciary Committee. I was intending on kind of focusing on exactly what you want to talk about
Yeah,
here as
yeah,
opposed to.
Please do. I mean, you've heard the discussion, and I think you've heard the testimony this morning. So, yeah.
The ABA doesn't agree with the separation of, they agree with the separation of competency and sanity as two different issues early on in the case, but they don't agree that evidence of sanity at the time of the offense should not be gathered by the evaluating individual early on, because the best time contemporaneous to do that is as close to the time of the event as possible. The legal issue of whether or not somebody is going to raise an insanity defense can only arise when the defendant is competent, because that is a choice that is like changing your plea or going to trial or the like. That is solely a choice of the defendant. The lawyer doesn't make the choice of bringing a sanity or insanity case. The lawyer may discuss the options, but that's solely the choice of the defendant, and the defendant can't do that unless they're competent. So the first initial stage is, are they competent? If they are, what defense are you going to use? There are people who have absolute sanity defenses who refuse, for various reasons, to pursue a sanity defense because many people don't want to be found insane at the time and have the ramifications of what that might bring. By the same token, many people who regard to competency is not the choice of the defendant, and competency is not a defense. Okay, competence.
It's a mandatory evaluation.
Well, it's what we call jurisdictional.
Jurisdictional.
You cannot be subject to the jurisdiction of the criminal court if you are not competent. And at that initial time, the prosecutor, the court, and the defense counsel all have the exact same interest. That is, not to have somebody who is incompetent be subject to the jurisdiction of the criminal court. Right? So one of the things that gets convoluted and confused about this, like we say these words, but many prosecutors perceive competence as a defense. It's not a defense. It is a jurisdictional prerequisite. So once we get to that level, let me talk a little bit about then you can make the decisions about sanity down the road, but you still need to collect the evidence of sanity. So in the event that somebody is found incompetent, they have the evidence available to them to make a choice about what defense they're going to use.
If I may, how do you collect evidence on sanity if you're not able to do a sanity evaluation? What can you give examples or just kind of step us through that?
Well, we've been doing this in this way. This statute has not been tinkered with except for last year for decades. We've been collecting sanity and competency evaluations right along. We've been ordering competence and sanity from the very beginning, and psychiatrists have been doing this. It is interesting to me, having been involved in this business for a very long time, that this has become now an area of dispute, that we want to jettison the collection of this. The issue that arises is when you are talking to somebody about sanity issues from a legal standpoint, that person needs to be immunized from any testimony that they might give or statements that they might give to a doctor relative to the evaluation, so it can't be used against them at a trial later if sanity is not the defense that they want to use. Right? Our statute provides for that, and that's why we've never really had a problem with it. The concept, like the doctors have kind of moved into now this area of well, I can't examine somebody who is not competent to make a decision about whether or not they are going to make a sanity defense. I don't even care, and lawyers don't care if they actually make a determination if somebody is sane or not. We just want them collecting the evidence that's available. So that is done by the same thing that they do with or some of the same things they do with competence. Do they have pre-existing major mental illnesses? Do they have, what are their law enforcement contacts been? What are the particular facts of this case? You know, do the witnesses, they'll see the information in affidavit, and perhaps some discovery material that's provided. You know, do we have witnesses talking about people acting delusionally, responding to hallucinations or auditory, visual, whatever? What are they saying and doing and acting by collateral witnesses at the time? That's the way you build insanity defenses anyway. Now, I will tell you as a practical matter, at trial, Vermont doesn't have a sanity defense. You might be surprised to hear that. It's available, but in the collective memory in the last 50 years, there's no lawyer, and we have had no evidence that any jury in Vermont has ever found somebody not guilty by reason of insanity. The way we tend to get there is both the prosecutors and the defenders see someone who is obviously not sane at the time of the offense, and they agree. The other way it's done is if the state doesn't want to agree or stipulate to it, the state will put in the information in affidavit. The defense will present the evidence of insanity to it, and they'll waive a jury, and the defense will put in the evidence of insanity. The state will not rebut it, and the judge will make a finding that the person was insane at the time, and then we go from there. But as far as jury verdicts, there haven't been any. They don't exist. So one of the things that I always say to my lawyers, if you intend to win a case, you better not be using an insanity defense because they don't work. The unfortunate thing is people who have major mental illness and are insane, they scare the hell out of people. And 12 jurors look at what happened. I can tell you about a case I did where tried this case for 10 days. It was a kidnapping, attempted murder. The guy, built a funeral pyre in the backyard to get rid of the body after he, it was an awful case. And he was responding to hallucinations in the courtroom during the trial. We were dealing with competency, we were dealing with sanity. Kept saying, well, yes, he's obviously psychotic, but he doesn't know where he is, and then he's on trial for this very stuff. Tried the case for 10 days. I'm like, well, they got something to chew on. I'm going to drive through the drive-thru and get a burger while we wait for hours or days for the jury to come back. Get a call while I'm in the drive-thru. Jury's back. Came back, guilty on everything. 2 weeks later, I see one of the jurors on the street who actually runs across the street to see me and says, "Man, you did a great job in that case." I go, "Geez, you guys were up 10 minutes. What are you talking about?" So yeah, that guy was really crazy. We were never going to let him go. Well, that's the common response, right? I understand it. So sanity is kind of this, it ends up being a very technical kind of thing dealt with between lawyers, doctors, psychiatrists, psychologists. It's not a real defense when it comes to the system.
So I'm going to ask you, because we've been hearing about the separation and from our ledge council, as you know. And so I think because of our time.
I didn't expect you to really deal with that issue in this committee.
Yeah, no, we're not. We're not. That's not our jurisdiction. Our jurisdiction is really relevant to the forensic psychologist, forensic psychiatrist, and then some of those pieces. We haven't talked about some of the other pieces, but
right. So let me just deal with that. The forensic psychiatrist,
please, and then Senator Hardy has a question first.
Well, I was trying to follow everything you were just saying, but I know this isn't our jurisdiction, so I am confused now. Are you saying that you're opposed to something in the bill that as it came out of judiciary because of the timing of the evaluation for insanity?
Yeah, and I'll deal with it in the House. I've done this for a long time. I know deal with it.
He's just trying to be
right now. I know that where it starts is not where it ends.
So, yeah, well, thank you. I wish everybody understood that, but Could you just tell me where in the bill that you're specifically?
It's right at the very beginning where there's the split of
Separating them out.
separating the sanity evaluation from the competency evaluation. And as I indicated, I'm not concerned about whether the evaluator opines as to the issue of sanity. I just want them collecting evidence that can be used by somebody else down the road. Usually we would be using, this is the interesting thing. Psychiatrists are the ones by statute who do evaluations currently. But when defense deals with those evaluations, if we disagree, we might use a psychiatrist, but we also often use forensic psychologists.
Yeah,
They will come in and testify as to why this is wrong or this is right. They use different tools than psychiatrists do. The interesting thing is I do understand what the doctor's saying about, well, there might be medical issues that can give rise to incompetence. Psychologists are very attuned to those things. It's not unknown to them. One of the guys I use routinely regarding certain types of like drug psychosis sort of things. This guy, Dr. Scott Lucas, who teaches at Harvard, he's kind of wrote the book on behavioral pharmacology. And so, yeah, he's not an MD, but he knows more about drug interactions and the impact on your mental health and the like than almost anybody in the world. He teaches, he's at McLean Hospital, teaches at Harvard, and this is like his thing, but he's not an MD. So what we find is that it's not just the people who are in Vermont. We go out of state to get doctoral level psychologists, and it's not just PhD level psychologists, but it's also PsyD psychologists, doctors in clinical psychology, as well as doctors in the PhD level psychologists. We use those now in cases, but what they can't do in Vermont and also in Rhode Island is to do the initial evaluation of competency and sanity, yet we use them for evidence in the cases after the fact. What I was trying to get at, and this was on the S3 study committee, and one of the number of recommendations that I made in my statement in a sort of disjointed accumulation of reports, I guess you could say, that was the S3 report, was we need to broaden the pool of individuals who are legally able to do these initial evaluations because we're waiting too long. Competency, as we have heard, is a fluid concept. Mental illness waxes and wanes, people's competence changes over time. A month from now, somebody may be competent, but at the time the lawyer met them at the courthouse, they were obviously not competent, but we're scheduling things 6 months out. And then we get an evaluation then, and by the time we get to trial, we could be at a whole different spot. We even saw this in the Garung trial that was most recent, where he was incompetent. He became competent enough, I guess, for trial, but in between trial and sentencing, he became competent again, and he can't be sentenced. So this is the kind of thing that you see with competence as opposed to sanity at the time. And so for us, the quicker we can get things, acquire the information, get things done, the better. And that's both for sanity and competence. And so that's why I had suggested that we broaden this pool to doctoral level psychologists, many of whom, and what they will see when they get the records is, oh, this person has various medical problems that might also give rise. They might say, look, I want to refer this to a doctor or
what I'm hearing you say is that those medical records are available during the competency evaluation.
They can be. I mean, this is one of the things that is a bit of a problem right now.
What is the problem?
Well, defendants who don't want to be found incompetent refuse to sign releases. And they refuse to allow their lawyers to get the records. If the court orders it, that's fine. I mean, the lawyer has an ethical obligation, if they see somebody who they think is incompetent, to say, we need a competency evaluation. If the court orders it, Department of Mental Health or whoever the psychologist is can use the order to acquire whatever they need to do it. And the lawyer doesn't have to violate any ethical obligations to the client in making that happen. So that part's fine with me. The issue of competence restoration is a very ticklish one. It has, if Vermont ends up going down the road of we're going to see competency restorations only, for example, only for life in prison cases, something like that. Forget about the Defender General's office litigating it. You're going to have significant out-of-state interests coming in and litigating that issue. There are constitutional concerns about doing something like that. And lawyers
Extremely problematic, isn't it? Yeah.
yeah, lawyers suggest, and it's a split even within the medical community about it. Should a doctor be restoring somebody to competence so that they can go, the doctor refers to it as resolve their criminal charges, go to trial so they can be convicted of something that they might do life in prison for, while even if they are restored to competence, they're still struggling with a major mental illness. Some doctors are not as keen on that as others. I understand the public safety concern, but don't think that's not going to come with a ration of stuff.
I'm going to have Senator Hardy ask a question, and I'm going to ask that we kind of wrap the conversation up as much as you can.
Okay, two
Go ahead.
questions that
Sure.
hopefully you can just answer quickly. So I think I'm hearing you say that you're okay with and in fact support the inclusion of having PhD level psychologists.
Yeah,
be
it was my
able to-
suggestion.
Okay, great. And that,
I hate to argue
I know
with
there's only a 1 year thing and then there's the study, but even in that 1 year window, you think it's a good idea that we should start right away.
Yeah,
So that you need the people. Okay.
Yeah.
Excellent. And then related to the competency restoration, that's also just a study done by DMH and Dale. Do you think somebody else should be added on to that, or language about consultation with some legal people? Because I know that.
Well, as long as they consult with all of the relevant people, I'm hoping that a study would do that.
Yeah.
They could, if they're running the study, I guess they could just talk among themselves, but I would hope they wouldn't.
Yeah, I mean, I'm assuming they will. It doesn't specifically
doesn't
say
say
they
it in
have
there.
to. So I would think they would be silly not to, but if you want the assurances that they do consult with other people, we can add that in.
And again, this was I didn't know you were gonna really talk about that, but I have a list of things to
We
deal
talked
with.
about
Deal
it
with in the
yesterday.
house, too.
Yeah, I suggested that we put in stakeholders or interested parties yesterday, so I think that would be part of.
Yeah, because I think your points about the ethical considerations about the restoration of competency are super interesting, and I hadn't thought about them because I hadn't really thought about this until this bill.
Well, but honestly, there have been, I think there was a movie about this. I'm trying to remember where all of the ethical principles just came falling down.
Yeah.
The one last thing I did want to comment about, and it was brought up, I thought the portion about the moving party shall pay for the
Oh, yeah,
evaluation.
good point.
I thought that was out. I didn't think that was still in the bill.
Okay.
And these were some suggestions that were made by the prosecutors, but in the testimony, it doesn't change anything. Well, if it doesn't change anything, then don't put it in. The bottom line is now, the first examination, the competency evaluations they don't come out of the state's budget, they don't come out of the Defender General's budget. I think it's in DMH's budget. I don't believe the court has a line in it. If we challenge that evaluation as not being appropriate procedure or didn't look at all the stuff, well, that's on us, and we have a budget for that in our other personal services line. And I said this to the Judiciary Committee and obviously to Senator Sears, who has our budget in the Appropriations Committee, that if this part is going to get shifted, then shovel millions of dollars into the DG's ops line that is somewhere else. But it's not really appropriate. And again, it's because of this concept that it's jurisdictional. It's not a defense motion. It is a jurisdictional prerequisite, and it's supposed to be an independent examination. You don't want the defense picking, or the prosecutor picking who the evaluator is to do the initial competency evaluation. And so, like, I think that part should be struck from the bill. And I actually thought it was going to be until I saw the latest version when it
Eric,
came
do
the other
you,
day.
whether that was supposed to be?
No,
struck?
it's
I'll
supposed
talk
to-
with
it's supposed
Senator.
to stay in.
We're supposed to stay in?
Yeah.
Okay, well, okay.
What
I'll talk with
are you talking about there in section 1, that about the insanity? The defendant shall be responsible for hiring the defendant's own forensic evaluator for the purpose of establishing insanity, provided that the state shall pay for the
No, it's
evaluation
not.
of an indigent defendant.
Oh,
Is that?
there's another,
Page
There's
three, page 3, so
Yeah,
subsection
first
G,
part.
I think it's
Subsection
Right.
G,
B.
B.
it's the
Oh, I
examination of, that shall be at the expense of the moving party. And if that's not changing anything, that shouldn't be there, because that confuses people. You know, people have said, and you know, non-lawyers looking at that go, hey, there shouldn't be some deterrent for people, and there wouldn't be. You know, honestly, there's an ethical obligation. If you see something as a lawyer that bears on competency, you've got to ask for that, and wherever the money comes from, that's not the lawyer's fault or problem. So it wouldn't do anything. Allegedly, it doesn't change anything. So it shouldn't be there. That's my opinion.
Okay,
And I'm always available if outside of committee or the like, anybody has any questions.
I
know
may,
this, I did a very
I'd like to
personal-
connect with you at some point outside.
Sure, and you know, this is a very cursory discussion of a couple of discrete issues. So, thank you.
Thank you. I appreciate your being available. Questions? We have a lot of questions. You know, there's no doubt about it.
Sure.
And then we have another meeting on Monday for the whole, the council, the Supreme Court.
On Monday, I don't know.
I don't know.
I'm supposed to be in
Must be.
Bennington on Monday.
Oh, okay.
That's the one day of the week I have to go to.
All right, thank you.
Thank you.
So Eric and Katie, you can see where we are.
Yeah.
But this has been really helpful just to hear from folks. So Matt, if you want to sit over here, you're welcome.
Thank you.
So Eric,
Oh, okay. Just had my head on, but no.
so what I'm going to suggest to the committee is, Eric, you've heard the bulk of the testimony when it comes. And there are some areas I think that we might like to address in an amendment. It'll have to be a floor amendment.
Right.
Obviously, and I've sent a note to Senator Sears asking for some time, hoping that the two bills wouldn't be taken up until Wednesday. When are both of them on notice today? I think they are.
I know this one is, I don't know about that one.
They both are.
89 has been up there for a bit. Now this one is up.
Oh, actually, this one is too, 91 is too, no.
Yeah, now
That's
it's on
second
notice.
reading, I think.
So I'm hoping that he'll allow for us to wait until Wednesday to provide some time so we can put together an amendment. And obviously the areas that we would have concern were the things that we've been hearing about, including some of the committee and who's on the committee for evaluating competency restoration, the issue.
Did you mean the committee, and I don't mean to interrupt, but I certainly would need more guidance. I have heard
No,
the
no.
testimony, so we can go through it maybe, if that helps, or
Yes,
whatever you want to do.
then I suggest that in just a minute, but what I'm
Okay.
gonna say is what I'd like to do, you hit the nail on the head. I'd
Okay,
like to go through the bill
Okay.
very briefly, identify those places where we have concerns, and we've heard a lot about them. And then I'm gonna suggest that I work with Eric and then put together some preliminary amendment that we could review, get it out to folks, and then look at it here in committee on Tuesday. And Katie, we might do this similarly for 91. This is where we are. So let's go through the bill.
Sounds good.
Yeah, good, thank you.
Mhm.
And then I'm honestly not thinking we're not gonna have a mile-long amendment, 20 pages, but we'll just have a few
Right.
things here and there.
Do you want to go, a couple of notes that I made that might be specific. I know they're at the end of the bill, but I don't know.
That's okay,
Is
do
that
it,
all right?
go ahead.
Yeah.
It's all yours.
So I think so with section 7, the Common Sea Restoration Program plan.
Yeah,
I think I heard you say that you would definitely want to add DMH and Dale in consultation with interested parties, or
yes.
something along those
Yeah.
lines, so that they're,
Is
Be sure.
there, are there specific people who we should be mentioning? Or is it gonna, or is there clarity with that? And I'm looking over at Nicole. Do you think that, I know DMH and I'm also looking at Karen Barber and Stuart Schuer, who are also here. Should we be mentioning specific parties in this area for you to work with? Or is interested parties sufficient?
Karen?
Good morning. For the record, Karen Barber, General Counsel for Department of Mental Health. I think interested parties is fine. We would have done that anyway. And so I think that language is sufficient.
All right,
Yes, Senator
fine.
Dale concurs with that.
okay, good. And there may be different parties for
Sufficient for
different
you now?
folks. And you'll be contacted. I'm sure you'll be contacting the Defender General as part of that.
Yes.
Okay, thank you. All right, go ahead, Eric.
so that was all I had for that section.
Yep,
For the next one, justice oversight, there were 2 possible
yeah,
things I noted. One of them, I think the easier one in a sense, is, and you're talking about again this morning, whether the consideration by justice oversight about expanding the nature of the professionals
Yeah.
should also include some consideration to whether access to medical records is sufficient to permit or refer to a psychiatrist when it's appropriate. In other words, because the phrasing currently, or at least for the next year, is going to permit doctoral level psychologists to conduct these sorts of evaluations. There was some
what page
testimony.
are we on here for that?
Well, that part is on page 10,
Yeah,
on the lines sort of 15 through 17. But it's also referencing the idea that for the next year, you're going to, for the first time, in Vermont at least, permit doctoral level psychologists to conduct these evaluations. The question had come up, well, might there be some particular instances where, because of an underlying medical condition, that you might want a
Yes.
psychiatrist also be involved? So might you want to just somehow fold that concept into something that justice oversight
very
gotta look at.
definitely.
So make sure that they consider that issue too. So that was one thing I noted, and I can certainly do that. And the other part, I think Senator Mind you mentioned is I don't know where you want to end up on it, but just wanted to remind that the thought had come up was, do you want this committee involved in that study? That off-season, that interim study you mentioned, the possibility of that. In other words, do you want health and welfare to be consulted, say, by justice oversight?
Yeah, I'm
Something
trying to
along-
figure out how best to do that. I mean, ideally, members of this committee and the healthcare committee in the House would be invited or would be named as participating whenever testimony is being taken,
Mhm.
and then to provide recommendations. So I haven't talked with the powers that be
Sure.
about having a per diem, should that be possible. But, so for now, I'd like to add something about, I wrote down a little thing yesterday about having, attending up to X number of meetings, where consideration is being given here. So that would define the number of meetings that justice oversight would commit to commit, that's a good word, to this. And then the possibility that members of health and welfare and healthcare would participate in those meetings and hear the testimony, and then be and contribute to, recommendations, so be part of any meetings where, because justice oversight does tend to make recommendations, and you say, well, who would like to help sponsor this bill? And I think that it would be important for us to be, I'm there already, and I don't know if anyone on healthcare is there, but this committee and healthcare in the House are significant. So I think my job is to find out how many people, based on how much money we can put into the budget for this.
But in the meantime, I can put some language in
Yeah,
to
that's
cover
what I
what
was-
you're addressing. and,
Yeah. Yeah.
Loop back when we talk, maybe you can let
That
me know
would be
what you
good.
found out. Yep,
Yeah, okay, perfect.
great.
Right.
So I had those two things for sort of definitive points. There's a policy question that's come up again this morning, and this is more of really a policy call as to whether you were just talking about subsection B on page 3, which is the examination, the initial psychiatric examination being expensive to the moving party.
I think I'd like
more
to
of
take
a-
that out. That, I don't know, what does the committee think about that? Is that our, can we do that? Is that our jurisdiction to do that? It's a jurisdictional examination.
As opposed to judicial committee?
Yeah, I don't know if that's I don't know. I'll talk with Sears about that.
Yeah, I mean, if it doesn't,
I don't want to step on the toes of judiciary.
yeah, I mean, it's hard to tell whether it's our jurisdiction. If it doesn't change anything and it's confusing people and it makes it sound like there's a barrier, then it
Well-
seems to me that we should take it out. But at the same time, I understand that
Yeah,
it might be a judiciary thing.
Right.
And they could do it in the house too.
let the House handle it. But
But-
the point about, competency is our area. We want people to be evaluated if they wish to be evaluated. If they can't afford it, that's not good. And it does, is Defender General has changed the budgetary process. This might become a conversation in appropriations, so I'll have to remember that.
But the same language is in paragraph B, or it's not the same language, but that one is okay. The one I read out loud before,
Yeah,
that one is okay.
yeah.
Paragraph B at the bottom of page 1, Eric.
I think that's yes, so with
Okay.
respect to the sanity defense, I think that it's agreed that is the obligation to defend in those cases as opposed to the competency one.
Okay.
Okay.
Madam Chair, I believe that there's a comment out here in the Zoom room from Karen
Oh,
Barber.
thank you. Karen, go ahead, please.
Thank you. I would just ask, so we respectfully disagree with the Defender General on this point. There's a lot of testimony in Senate Judiciary and they kept the language in. So we would just ask that if you are considering taking it out, that you give us an opportunity to explain why we disagree and why we think the language is important.
Okay, well, I think we've agreed not to take it out because it is beyond the scope of our capacity in here right now, so I'll do that. Phew. This is why it's important to have you all in the room while we're doing this. Go ahead, Eric. Something else,
That was-
the
that was-
forensic psychologist piece.
Yeah, that's on page 3, you mean the piece that's lines 12 through 15. On page 3, that's the piece that for the next year permits forensic psychologists to conduct these evaluations.
So then the question, let's just look at that briefly. I was looking at the wrong bill, so I didn't have the right page. Lines, which lines?
Line 12 through 15 on
Okay.
page 3.
We might want to put some language in here somehow relating to medical condition and access to medical reports. Is that appropriate for us to do that, or is that such a big part of the process or the rules that it's not needed?
I think that, I'm looking for it now, I think that there was another place where the access to medical records was covered.
Paragraph C above that one
Is that one?
says.
Oh, thank you, yes, right there. Best place to That's why I'm looking elsewhere. It's
Okay.
literally right above.
That certainly helps.
Right.
Okay, and then any distinction that, let's think about this. I've been thinking about how we distinguish between the doctoral level psychologist. I know there's a lot of experience in other states. So I think we absolutely need to add that into any study and analysis. So I want to look at that section next. But do we need to add anything here?
I'm comfortable with this.
Yeah,
I think
no,
we
it's fine.
absolutely need other additional people, and that doctoral level psychologists have a lot of training, so.
I'm not disagreeing with you. What I'm asking is, do we need any modification of this because they're not medical practitioners? They do have an understanding, complete understanding. And I think I heard that they have an understanding of the differences between their practice and psychiatric practice. I don't want this to become, free for all, but we'll
I think that, and it's a good point, but I think that that's the idea of the justice oversight study, is that this, if you do nothing, this only lasts for a year and it goes away.
Yeah.
So the whole idea is that to
So-
study the exact points exactly like the one you're raising, which is maybe this isn't working quite right, and maybe it needs to be amended in a bunch of ways. So that's why they're given broad authority to recommend changes to it or even get rid of it. So if it
Let's
doesn't
go to
work-
that study section.
Yeah,
Can we do that?
sure. That's section 8, page 10.
Mhm.
And I think this is also related to your point there, Lance. Also by adding the piece that we mentioned in here about, they would also consider whether in certain situations referral to a psychiatrist was appropriate because of underlying medical conditions. That also goes to your point about, in some situations, maybe it should be a professional other than a forensic psychologist.
Yes,
But I think also the way it's phrased, that, if they're gonna make recommendations about that existing language you just looked at, including whether it exists, should continue to exist at all. So I think they'll be thinking about all those sorts of issues, as whether or
I
not.
think I'd like to include something about accessing, looking at what other states
Oh, that would be a good
currently
place.
do.
for it. Yep,
Yeah.
yep.
And then,
Other state practices.
Yeah.
Yeah.
and then I'm wondering how we can compound the fracture and have justice oversight doing this with members of, when we're including members of this committee and House Healthcare.
Right.
So those two then would be, it might be a full day, I could think of 3 or 4 full days of justice oversight devoted to these two things. There are 2 questions embedded in that. One is talking with the chair of the Justice Oversight Committee about this, and then looking to see, do we have budget to cover it? And how
Might be
many,
the same person.
huh?
Might be the same person.
I know, I'm thinking, it might be the same person. Okay, so, but let's frame that in a little bit with
Right.
having including health and welfare and healthcare.
Yep.
And I could keep your hamsters running on this, please, committee, and then I'm gonna, Alex, I just said Alex, Eric, please, put something together based on what we've just talked about.
Yes.
And then we'll define it.
Okay.
Yeah, and hopefully we'll be able to offer it before second reading or
Right.
during second reading.
And should I send it, maybe email it to Alex and
Oh, yeah.
yourself and
Yeah,
just sort of, then we can sort of
let
take an initial look at
everyone,
it.
let me look at it first, then
Yeah.
we'll fine tune it with everyone
Okay.
on
Sounds good.
Tuesday.
Perfect.
And then we'll include Senator Sears as much as possible, because I know this committee will want to see this.
Great. Sounds good.
Okay. Good for us. Well, that's good. No, I feel good about that.
Yeah, thank you. That works. We'll be back in touch.
All right. So Katie, do you mind spending a couple minutes with us. We might, I don't know, we're gonna have to go through this fairly quickly, but then I'm gonna suggest that we work with you offline and try and put something together based on the bill.
Sure.
Okay, thank you. Thanks for being here. So let's go into S89. Were you here when we were going through the bill and the
Yeah,
discussion?
Yesterday I walked you through
Yeah,
it,
I know.
and then you had some time with
Discussion.
Dale to get their input. I think you ran out of time before you heard from DMH on S89.
Yeah, we did run out of time before we heard from DMH. So let's go through and identify the places where we are as much as possible. And
Thanks.
thank you.
Yeah.
Thank you.
Nicole, or Karen, do you want to add something before Katie starts in? Very briefly, I'm sorry about our time. I can't, it's just like, life is short.
Sure. Thank you, Madam Chair. Again, for the record, Karen Barber, General Counsel of DMH. I'll just quickly, if I can quickly touch on why we think this level of care is so important. And because there was a lot of discussion about it yesterday, and really what are we trying to do? And I just kind of want to make it clear what we're trying to do. There's a lot of statutory changes to accomplish one primary goal, which is to create an entirely new level of care that doesn't exist now. We have a hospital level of care for those that need it. The target of this facility is individuals, who do not need hospital level of care, but continue to need a more secure setting than DMH or Dale can currently provide. And so the idea really is to create a physically secure residential level of care for those in DMH or Dale custody with the ability to perform emergency and voluntary procedures and to allow for involuntary medications. And this is because this new level of care is focused on those who both remain in clinical need of mental health or developmental disabilities services, but also remain a real public safety risk. And so we need to assure for their safety and the safety of other residents that we have the tools necessary to provide the proper care for these individuals. So that's kind of overall what we're trying to do. I'm happy to answer any questions, but just wanted to make it clear what we're doing here, which is to create something that doesn't exist now.
Yeah, thank you. That's a good umbrella for us to have. It's great. So why don't we'll go through the bill with Katie and we'll try to identify where we fit into this, knowing that it is a shared responsibility with judiciary.
Okay. I'm not logged into Zoom. Do you want the text on the screen, or does
Yes.
everybody have a copy of it?
Does everybody have a copy?
Could you put it on the screen?
Yeah.
Yeah. I keep finding the original copies.
Oh,
Yeah.
it's nice to have everybody on the same page.
So it's, the bill is introduced. Is there any changes?
It is not.
Oh,
the
no,
bill
it's
that's introduced.
Senate Commission. I got it, report.
It's 3.1, yeah.
We're good.
So I have to log into Zoom. It will take a minute or two.
Okay. We're on the floor, actually, 10, so we'll do what we can do.
Well, never
So-
mind, keep going. No, keep going.
Hold up just in time.
Oh, we're on the floor at 11:30.
Yeah, it's a
Bless your
regular
heart.
time, yeah.
Thank you so much. Okay, so that little support dog upstairs said I was under stress today, and I agreed with him.
Oh, I'm sorry.
No, I'm sorry.
Now the stress has been relieved.
Should we go get the dog?
Yeah, I did.
Oh, was there a dog,
Up in
literally?
the card room. Oh my God, it's so adorable.
A puppy?
And no, it's
Puppy,
a
let's bring the
lab.
puppy here.
Yesterday
Senator-
was cats, today is puppies.
Senator, we
Seriously?
decided we need a support.
There were cats here?
No, we talked about
Conversation.
cats.
We need
About-
we need
oh,
support.
And we all went
Yeah.
crazy about kittens.
I totally missed that
Oh, and I forgot
conversation.
this today. Okay.
I'm getting there,
Oh,
slowly
okay.
but surely. I thought you were going to be listening to departments, so I didn't have this.
Yeah, I
a minute
know.
ago.
Life is too complicated. We'll try to put something together. If we have recommendations for an amendment, we'll put it together. I can work with you. You'll send it out. We'll all come back Tuesday and be happy.
Yes.
Maybe. Let's see.
Okay, here we go. So this is a strike all amendment. And it's basically what we went through yesterday, if you remember. This was the bill to create the option for a forensic facility. And the bill in large part was broken into two major portions. One portion that pertained to sort of the admissions process for the Department of Mental Health, including the process for continued treatment and the process for involuntary medication, and how the forensic facility would be built into that piece. The second half pertained to Dale's admission structure. And then we had language exempting the forensic facility from having to go through a certificate of need, CON process. There were two rulemaking processes, one pertaining to establishing admissions criteria and the operations of how admissions would work. And then the second piece was directing DMH and Dale to amend its rules to allow for EIPs, emergency and voluntary procedures, emergency and voluntary procedures, EIP, and involuntary medication at the forensic facility. So those are the rulemaking changes.
I did write some things down, so we'll go through them.
Yesterday, if I recall, you raised the issue of the fact that the rulemaking dealt with what the admissions criteria was, and you were asking questions about what would the programming and personnel be like at the forensic facility.
Yes.
That helps jog your memory at all.
Yes. Establishing some criteria. The thing is, this is a whole new level and new system. So having staffing appropriate for those folks with intellectual disabilities and could be any level of disability or care. So we need to have staffing available for treatment and evaluation and treatment, and then appropriate programming available when someone is committed to the facility for involuntary treatment.
Well, I don't want to put words in your mouth, but what I'm hearing sort of sounds like you're wanting some type of report back on what the plan is.
That's
from
exactly what I was
from
thinking.
DMH and Dale for their programming and staffing.
Yeah.
Is that accurate?
Before it goes into rulemaking,
Well,
or do
I
we?
mean, the rulemaking starts in July. You could have it sort of concurrent with the rulemaking process.
Okay, we could do that. We could do that because the rules won't come to LCAR. And there'll be some time for us to give input. I don't want to have the rules come back here and then vote on them and all of that, but I do think having, allowing for time for us to provide input would be helpful. So the report coming back before,
November 1. So you time to
January.
react.
Nobody works on New Year's Eve.
So November 1.
Yeah. Go ahead.
So the facility itself doesn't take effect until July 1, 2024. So there's this year of rulemaking and planning and reporting, and then it takes effect. So the thing that's confused me about this bill, and I asked the commissioner about this, is that this isn't actually a new facility. It's just like
It's a new use.
9 beds in a current facility. So I don't know, Katie, if there's, I mean, I looked at the definition of forensic facility, and it doesn't mention anywhere that it's a subset of an existing facility. So because this would be, my understanding is like a higher level of security and have specialized care and also specialized kind of needs, I guess. I'm wondering if we need to add language that talks about this being part of a larger facility and that there may be different things that need to be done within a bigger facility.
Well, but it might not stay this way. I mean, right now it's 9 beds. Katie
Oh, I don't want to interrupt you.
No,
Finish your
go
thought.
ahead.
Okay, so I have a few thoughts about this. The way this is drafted is very generic. If you read through, you'll say we don't reference the forensic facility, we reference a forensic facility.
Yeah.
So it's drafted in a way that if there were another forensic facility proposed, this piece of legislation
Work for it.
would work for that. Yeah. Original drafts of the bill, included language like, do we need fit up? Do we need renovation? And it was, the administration had been clear that there wasn't a need for fit up or alteration of the unit within the psychiatric care hospital to make this possible. Does that preclude you from specifying, for the, that in this, I don't know how to say that it is our intention that the forensic facility would be located in a unit of the Vermont Psychiatric Care Hospital, or some language specifying where you see this happening? No, you could do that.
Yeah, I mean, I understand the desire to have it generic so that it doesn't have to be changed in the future if we remarkably build a standalone facility. But I feel like at least while it's in this facility, there needs to be kind of an honest mention of it in the
Some
statute.
session law.
Or in session law in the report back section or the rulemaking or something that is for this particular facility. And maybe it's part of what you're requesting here with the staffing, that, the staffing and the plan for how to make this work within a subset of another facility. Maybe DMH doesn't think they need that, but this seems
Madam Chair.
dishonest to me.
Let's go to Karen, and then we'll go through the bill and keep your comment in mind, and then we'll see where we land on it. Because this has been, this particular facility that you're talking about has been a conversation in justice oversight, and I think judiciary and institutions now for a bit, and I know from the department's perspective. So it's not, this has been worked over big time, but we'll keep that in mind, because it might work in terms of a session law or something else that would help people understand that there's a transition going on. Karen Barber.
Thank you, Madam Chair. I just wanted to note that this facility, as contemplated, will be licensed as a therapeutic community residence under Dale. And so there are a set of regulations that govern therapeutic community residences. Stuart can talk more about this, but there are guidelines as to staffing and quality. And so all of that will be set out in rule. What we did currently, the Middlesex Therapeutic Community Residence is licensed as a TCR. And when we created that facility, we built a separate section within the TCR rule that allowed certain things to happen at the secure residential that don't happen in normal therapeutic community residences. And as envisioned in this draft, the rule amendment that this calls for would add another section to those TCR regs, kind of laying out particularly the requirements for the rule. And again, it's a licensing, and so there's oversight and surveys and such. So I didn't know if that would make you feel better in terms of understanding what kind of quality and staffing metrics may be required at the facility.
So,
and it would be licensed separately from the rest of the hospital beds. So the 16 beds at VPCH will continue to be licensed as a hospital, will be CMS certified and Joint Commission accredited. We envision these 9 beds being licensed as a therapy community resident. So they are licensed as 2 separate levels of care under 2 different licensing jurisdictions. Does that kind of help a little bit?
I mean, it helps me to understand it. It's still just in the actual language of the law, whether it's session law or statutory law. There's no mention that this is just a subunit of a larger facility. And I think it's confusing.
Okay, look, I got it, we got it. And so this might be something I think that as it's funded is gonna have to be dealt with, but we can talk about that. We can talk about it as we go through the bill, and it might be something we wanna add in. And we'll have to run it by judiciary too. Katie, let's go through the bill and identify the rulemaking piece, I think, is important. Where are we in terms of the interest that we have in our jurisdiction, that we have in the bill?
Well, most of the bill is in Title 18, so
I know.
most, I mean, there's a few at least one that is in Title 13, but,
So Senator Hardy's comment, let's deal with that one first.
Okay.
This may well be either permanent or transitional. So the first forensic facility, we could talk about the first forensic residential facility, or the first forensic facility will be established, and then we can put down as a subunit or as a standalone unit. How do we write that? Because we don't want to get in trouble with IMD stuff.
so I'm wondering if you would consider like a legislative intent statement that says the forensic facility anticipated by the creation of this act would be at the Vermont, a 9-bed unit at the Vermont Psychiatric Care Hospital, the current.
I like that.
And then
Does that help you?
it's not binding, but we could put the statement to be the first section of the bill, so it's sort of clear moving forward what is anticipated.
That makes sense.
I mean, I'm not gonna die on this hill. This doesn't, I just, reading the bill, it's just confusing. I don't know if legislative intent, it doesn't sound like it's necessarily legislative intent. It seems like it's DMH intent. That they came to us with this proposal. And so, and is legislative intent statutory? Because then it would be permanent if we.
Session law.
It is session law, okay.
Same idea, different title. We sometimes have purpose statements. So the purpose of this act is to mechanize the admissions process for DMH and Dale to commit individuals in their custody to a forensic facility, which will be at also in session law.
Okay,
That's
I guess
good.
I like that better.
I do too.
because-
I like that. Good. It really does lay out exactly what's happening procedurally. Well, there's one. That's good. First Amendment.
Okay.
Thank you.
They will
That's
add
great.
that. Are we keeping the report?
Where are we now?
Sorry, this was the conversation we had about the plan on staffing and programming to come back November.
Yeah, so
11th.
let's, where is that? Let's go through the bill and briefly.
Okay,
Where is the report? Because I
there
think
is
that's-
no report right now.
Oh, okay.
So it'd be whether,
I'm getting mixed up with 89 and
I
91.
know.
Of course, you know that, right?
Too many bills.
Mhm.
okay, so I'll do a really high level since we went through as a section by section yesterday. Is that what you're looking for?
No, let's just talk about the report.
Okay.
You're right. So we would add in a report coming back to us. First, an update on the rulemaking procedure and what the rulemaking,
Okay.
an update on rulemaking. It doesn't have to be a report. We really want an update. I mean,
Like a
report,
presentation
yeah, let's
Okay.
do the presentation.
by February 1st of next year?
Yes, how's that? Is that okay? And then, including the things that we were talking about, and I know it's gonna be in the rules, but we're very interested in the staffing for the forensic facility, the services and programming that will be offered within the facility for those who are under the jurisdiction of both Dale and DMH, because they're gonna be two separate.
Yeah, I mean, the
How's that?
individual
But-
themselves will be under the custody
Yeah.
of a particular commissioner, but the facility will
Facility
be
is DMH.
operated jointly.
But we want to know what's available for the patients who are in there.
Mhm.
Who are under the jurisdiction of each,
Okay,
how that's managed. And who's in charge? I mean, if DMH is in charge, how are the services and programming managed?
maybe your question is, how will the joint operation work?
Thank you. See? Yeah, somebody knows what she's doing, and there it is.
I'm also wondering if you want to hear anything about money at that time. Like, is there,
Resources committed to? Yeah.
what resources
Provided
are
for?
needed, something
Yeah.
like that? Okay.
Yes.
Wouldn't that also be in their budget request though? Because it would be for.
Hopefully,
Yeah.
we don't know.
So mention it, don't mention it.
You can mention it. It's
I do
no
wanna
harm.
mention.
If they have it in their budget request, then they can just copy and paste.
Okay.
Yeah, it has to be in there. I mean, yeah. Yeah, normal, okay. And then also, I'm thinking, we want to know what the population is going to be. What do we see for the population that's going to be admitted into this facility? The numbers, we want to get some numbers about that. So,
Like the anticipated census of the unit?
yeah,
Probably 9.
well, what's the wait list and where are these other people? You know, this is one of the problems that we have.
I may not know that until they're,
Yeah,
I mean, I can add it, the anticipated
yeah.
census.
Is it a one-time report or a repeating,
This is a presentation, so it'll be one time, yeah,
one-time?
one time. And we can always, you know, we can always invite them back in to help us understand what's going on.
So I'll write something about the anticipated census and where will people go if no beds are available. Right?
Mhm.
Is that the question?
Then I guess as I'm looking, for example, on page 4, where the commissioner is seeking to have a person receive treatment in a forensic facility and so on. It would be helpful to keep track of those requests that are not able to be accommodated. So that's the kind of information that we're looking for. What would mean the commissioner is going to receive on page 4. Okay, they're gonna receive application for treatment.
Okay, so now what I'm hearing is a separate report that is forward-looking, so
Yeah.
and maybe the census would be part of that, that
Yes,
every year you want a census and you want to know if
there's any waiting
with the
list.
backlog.
Backlog.
Okay. So that would be ongoing? You want that every year?
Yeah, because it will inform whether we have sufficient number of beds to accommodate the
Can we just
backlog.
have them put that in a report they already give instead of having a separate report? I'm assuming that
Yeah,
DMH
no.
has some.
If this is part of their presentation, they won't have it yet until the forensic facility is operational.
No, but I mean, if we're gonna do it as an ongoing report.
Oh, I see what you mean.
There was the Act 79 report, and I don't know if that's.
Why don't we do it this way? Upon request,
Okay,
the department shall have available, and then they don't have to make a yearly report, because we get these reports all. Can we
okay.
do that way? Census report and numbers of those who are have made application but cannot be accommodated.
I mean, yes, I can put that in writing and we could have that,
Figure out.
upon request, that is information they should be able to provide to you anyway,
Yeah,
probably without language, but
Yeah.
if you want to have it, I'm just trying to think also where to put it. If it's ongoing, it should be, it should be in the green books, but then do I put it in Dale's section or DMH's section? I guess I could put it in both places and cross-reference it,
okay,
something like that, if
okay,
that's what you'd like.
okay.
Okay. Okay, I will put that in.
All right, a lot of this language, we're going, I'm on page 5. I want you to take us through.
Okay,
Yeah, just the underlined section.
right, so you're on page 5, so which section are we in? I'm on page 4. Well, page 4 starts, has section 3, and it sort of walks through the admissions process. So first we have a section about the application for the involuntary treatment. And that section specifies that the commissioner has to say that treatment is sought at a forensic facility and why the commissioner thinks that's the appropriate setting for the particular individual. Then the next step is the court has the hearing on that application for involuntary treatment. And we have language about the court can consider an expedited hearing, a motion for an expedited hearing, and the circumstances in which the court might grant that motion. And then we have language, if the court does grant the motion for the expedited hearing, the time frame for the hearing. Next, in section 4, bottom of page 6, top of page 7, that's the actual court making the order for non-hospitalization. And so that specifies that if the commissioner determines that treatment at the forensic facility is appropriate and the court finds that treatment is the least restrictive to meet the person's needs, then the order is made. And we have consistent language that it will be for up to 90 days.
Yeah.
And that there's an opportunity, the court may at any time on its own motion or the motion of an interested party review the need for treatment at a forensic facility.
Yeah, I don't, does anyone want to make any comments for change there?
And we keep kind of marching through the process.
Yes, please.
After 90 days, if the commissioner feels that the person should still be receiving treatment, they can file an application for continued treatment. And then we sort of go through the same process again of application, hearing, order. So this embeds the forensic facility into that process. Section 6 is the hearing on the application for continued treatment. Not as many changes there because we already had to make a lot of these changes for the possibility of an ONH at the secure residential. So now we're just adding or forensic facility to that list. Section 7 is the application for involuntary medication. So as we discussed, under current law, there are 6 situations in which the commissioner could seek involuntary medication. And this proposal adds a 7th situation that confusingly is at subdivision 6. But that is when an individual has been placed under an order for non-hospitalization in a forensic facility or has an application for involuntary treatment at a forensic facility pending for which the court has granted an expedited motion, regardless of whether the person has previously been under an order of hospitalization before.
So this is number 7.
Yeah, well, yeah, I've inserted it in the middle of the list and I had a reason for doing that, but I can't remember at the moment.
That's okay.
I'm sure it was a great reason at the time.
You're very empathetic.
And then, let's see, make conforming changes. Section 8 is the court findings on the order for involuntary medication. If for a person receiving treatment pursuant to an order of hospitalization at a forensic facility If the court finds that without an order for involuntary medication, there's a substantial probability that the person would continue to refuse medication and as a result would pose a danger of harm to self or others, the court may order administration of involuntary medications at a forensic facility up to 90 days, unless the court finds that an order is necessary for a longer period of time. An order for an involuntary medication pursuant to the subsection shall not be longer than the duration of the current order of hospitalization. So you can't order involuntary medication longer than the order of the ONH.
Right.
If at any time the treating psychiatrist finds that the person subject to an order for involuntary medication has become competent, the order shall no longer be in effect.
And this gets into the competency piece, but yeah. Okay.
And so that language is existing for orders of involuntary medication. If the person becomes competent, then the order no longer stands.
Go ahead, Senator.
What do they do right now? Without this bill
Without this
directing that?
facility.
Yeah.
Well, right now, folks might be in the secure residential recovery facility. Some folks might be on an inpatient psychiatric unit. Some people may be in a correctional setting. If you want more specifics.
Somebody already orders the medication if they need it.
Right now, in a hospital setting, if the person is on an order of hospitalization versus this would be an order of non-hospitalization, then yes, if the person fits into one of those 6 categories, the commissioner can make an application for involuntary medication.
So order of non-hospitalization means you're out somewhere in the community.
Or in a facility,
facility.
yeah.
And talking to somebody, one of our colleagues on the Judiciary Committee, I think they heard testimony that a number of these people are actually in a correctional facility.
Yes.
So that's really problematic that.
Okay. I don't want to talk offline sometime, but
We can do that. Yeah, there's a lot here. There's a lot here that we have not,
Yeah.
that we're not.
thank you.
Now we're in 11 minutes,
Mhm.
Madam Chair.
Should I talk faster?
Well,
maybe
I think we're gonna have to do some stuff offline, unfortunately.
Yeah, so the next sections are the admission process for Dale, so individuals with an intellectual disability. We've kind of walked through this language yesterday, but there's this section in Title 13, so this is the criminal title, that if the court finds that such a person is a person in need of custody care and rehabilitation, the court shall issue an order of commitment to Dale for placement in a designated program in the least restrictive environment consistent with a person's need for custody care and rehabilitation for an indefinite or limited period. So that is an amendment to 13. And then would also, instead of the process for admission that isn't actually in effect, that this bill strikes through, there's language that the judicial review procedures for an order issued for the section and discharge from an order of commitment happens pursuant to 8845 and section Title 18, which is.
As you're
this bill.
going through this, I'm getting deja vu of when we went through ONH.
I know,
I know, it's just like,
yeah.
I don't want to do that again.
Well, this is different. I mean, this is different because it's narrow in scope to the forensic facility.
So much.
And we have language that if the commissioner seeks to have the person committed pursuant to this section placed in a forensic facility, the commissioner shall provide a statement setting forth the reasons for the commissioner's determination that clinically appropriate treatment and programming can be provided safely only in a forensic facility. So this is very much parallel to the information that the commissioner of mental health has to give when filling out an application, stating that the application is for treatment in the forensic facility and why that treatment is appropriate and safe and least restrictive. Then we get to Title 18, we have changes in definitions, and you wanted to spend some time looking at person in need of custody care and rehabilitation. So that means a person with an intellectual disability, which means significantly sub-average intellectual functioning existing currently with deficits in adaptive behavior that were manifest before 18 years of age, who has inflicted or attempted to inflict serious bodily injury to another, or who has committed an act that would constitute a sexual assault or lewd and lascivious conduct with a child, and for whom appropriate custody care and rehabilitation can be provided by the commissioner designated program. And then the concept of continued custody care and rehabilitation is added, similar to a person in need of continued treatment or further treatment in the mental health statutes. It means a person who is previously found to be a person in need of custody care and rehabilitation, who poses a danger of harm to others, and for whom the commissioner has, in the commissioner's discretion, consented to or approved the continuation of a designated program. A danger of harm to self or others shall be shown by establishing that in the time since the last order of commitment was issued, the person has inflicted or attempted to inflict physical or sexual harm on another by the person's threats or actions has placed another person in reasonable fear of physical or sexual harm, or has exhibited behavior demonstrating that absent treatment or programming provided by the commissioner, there is a reasonable likelihood that the person would inflict or attempt to inflict physical or sexual harm on another.
So the programming report and information that we get regarding rules is going to be really important.
Okay. The next 4 sections are the sections that are being removed. And we have
Good.
language about legal competence. So no determination that a person is in need of custody care and rehabilitation or in need of continued custody care and rehabilitation. So again, adding that concept in. And no order authorizing commitment shall lead to a presumption of legal incompetence. And then there is amendments of the judicial review procedure that are referred to in Title 13. So a person who's committed under the criminal statute or this subchapter may be discharged from custody by a superior judge after judicial review as provided in accordance with the subchapter or by administrative order of the commissioner. At least 10 days prior to the effective date of any administrative order discharged by the commissioner shall give notice of the discharge to the committing court and to the state's attorney of the county where the prosecution occurred. A person committed under the criminal statute or this subchapter shall be entitled to a judicial review of the person's need for commitment annually. The family division of the Superior Court shall have exclusive jurisdiction over all judicial review proceedings brought under this section. If no judicial review is requested by the person within 1 year from the date of the last order of commitment, it shall be initiated by the commissioner. However, such a person may initiate a judicial review under the subsection after 90 days of initial commitment, but before the end of the first year of the commitment. Or if commitment has been continued under this subchapter, the person may continue for review after 90 days from the date of the order for the continued commitment.
I have a question, but keep going.
Okay.
I'll ask because I don't want to stop progress.
Okay. If the commissioner seeks to place the person committed pursuant to this subchapter in a forensic facility, the petition shall expressly state that such placement is being sought. The petition shall set forth the reasons for the commissioner's determination that it's clinically appropriate treatment and programming can be provided safely also only in the forensic facility. This is the same theme of having to state the intention. The Vermont Rules of Evidence and Procedure applicable in civil cases shall apply. This is not this committee's jurisdiction. The commissioner or commissioner's designee shall attend the commitment hearing and be available to testify. All persons to whom notice is given may attend the commitment hearing and testify, except that the court may exclude those persons not necessary for the conduct of the hearing. If at the completion of the hearing and consideration of the record, the court finds by clear and convincing evidence that at the time of the hearing that the person is still in need of continued custody care and rehabilitation and commitment shall continue in a designated program, the least restrictive environment. Can we keep moving?
What?
Oh, I wasn't. Oh,
I know.
We need a minute or two.
We're gonna have
We're
to
be in-
quit, but what page are we on?
We're at the end of the Dale section.
Yeah, so I forgot, the certificate need, I think we're.
You're fine with, and then it's the tool rulemaking provisions.
Then we want to have that preliminary report back, so.
So-
Can I work with Katie on that, please? And the other question I have is,
You're the
we'll
chair.
just bring it back here and we'll all dive in. And please look at the bill, and if you have suggestions, let me know, and because it's important. I
Okay,
know.
I'll just make one
I
comment.
have one comment
Oh,
first, and that is my question of Katie and Nicole is, when someone is discharged, is there any, what's the planning that goes on for them within the community? Question, need an answer, that's all. Okay. Thank you.
How does this survive the whole equity issue? We keep tripping over that kind of at the last minute, that we get some, we hit a speed bump upstairs, and I'm just kind of wondering, and frankly, I think this is all fine. It's,
Yeah.
Bits and pieces need, but anyway, that whole,
Which equity issue are you talking about?
it's disproportionately affects one community versus another, and blah, blah, blah.
Well, we could ask for records, and we can ask for a presentation. I'm looking at Nicole, she's shaking her head. Let's put that in.
We hit that every time.
Yeah, let's do that. Let's throw that in there.
Better to have it during the report than
Yeah, then come up
And
the
with.
challenge.
Do you have any specific suggestions?
No,
like to
no.
make?
That can be on the report back, demographic
Yeah.
information.
Good.
Yeah, thank you, Senator.
Excellent. Thank you all. We'll get 2 amendments on our table on Tuesday, Katie, and we can chat
Yeah, maybe I'll just run by what I have and,
Yeah.
you have to be upstairs.
Can we do it later?
Yeah, we can do it later.
All right.
We're happy to be available as needed. We'll
Thank
talk to
you.
on Monday.
Yeah, and Katie we can just have the email chain.
I think you're still on live.